with Deputy Chair Baker. Thank you very much, Mr. Chairman, and thank you to the witnesses. All three of you are very well known in case law. You're performing extremely well as criminal defense lawyers. My question to you is this. You've compared the wording of this particular bill to the wording of existing provisions in the code in saying, well, it's already covered and that it would be in conflict with the Gladue principles. There's a considerable difference I see in the wording of this bill and the wording of the of 718.2 A, and that is the section that deals with the mitigating and aggravating circumstances. That provision deals with circumstances that shall either increase or decrease sentencing, depending upon whether it's an aggravating circumstance or a mitigating circumstance. In other words, the provision in the code says the sentence shall be increased or shall be reduced. That's quite different than this bill, which says a judge shall consider in sentencing. Not shall increase a sentence, not shall decrease a sentence, but shall consider as an aggravating factor. There's a considerable difference in the wording. And if, as you say, Mr. Friedman, you're a very experienced litigator, you say that, well, it's really not going to have that much effect. Well, why would you call it bad law if it's not going to have that much of an effect? But I think my main question is that this bill is worded in such a way as to try to address a very serious problem we have in Canada, and which is, as you say, presently being studied. And so the bill is so worded as to provide a direction to consider, not to increase or decrease, but to consider as an aggravating factor. You can't compare that to a section that says it must be increased or decreased, aggravating or mitigating. That's my general question to you. Any comments?
Maybe I'll just I'll respond. When I said that it won't have much effect, what I meant is that it will have no beneficial effect in terms of deterring offenders from committing offences against Aboriginal women. The research on the benefits or lack thereof in terms of sentencing provisions is fairly clear-cut, and the benefits, if any, are extremely slim. With respect to the issue of aggravating features on sentencing, I look forward to the day when I meet the Crown Attorney who's willing to agree that an aggravating feature should not increase the sentence on an offender. Considerations are aggravating, meaning that they call out for a harsher punishment. That doesn't necessarily mean it's automatic imprisonment, but it means that you've lost some benefit and you will now be subject to stricter sanctions. I think we have to look beyond, however, the hate or prejudice provisions. If we look at 718 itself, we are told, number one, we have to denounce the conduct. We have to examine the harm done to the victim and to the community. And it's interesting, I noted with interest the cases cited by Senator Dick. Courts are already taking into account the vulnerable nature of victims as individuals and classes. That exists in the common law. And specifically, I'll conclude by saying that 718 says that these are aggravating features that are not limited to the following. In other words, courts are entitled to take into consideration anything about the offense that they consider to be aggravating. The fact that the victim is vulnerable is absolutely one of those features, and it's recognized commonly in the case law.
But it's quite different from 718 in that 718 says a sentence shall be either increased or decreased depending upon whether it's an aggravating or mitigating circumstance. You obviously agree that that's what's there.
I agree that that's what the wording is, but the only meaning that aggravating factor on sentence can possibly hold is that the penalty ought to be
even though
increased.
It says consider.
Yeah, the judge will consider it.
Consider it.
And how does that reasoning process play itself out? The judge considers it, weighs it. Now, that aggravating factor might not be enough to tilt the balance towards a heavier penalty, but there's no question that it goes on that side of the balance. That is, the balance that leans toward a heavier penalty.
Okay.